in our profession on the academic side in the United States really developed some tools to think about the way mediators approach their problems. How narrowly or how broadly do they focus the discussions? Is it interest-based? Is it simply looking at what may happen in the court system if the case moves forward through litigation? How do they see their own role? How are they just eliciting from the parties and not offering their own perspectives or evaluation? One can apply those principles not just to the substantive conflict and what's going on in the conflict, but also the process.
Right.
One can be very facilitative and non-evaluative on the substantive area and still be very directive when it comes to process.
Sure.
So you got all these different things going on at the same time. And what we try to do is get people to realize that there is not one patented approach that all mediators should take. I contrast this with what I learned when I was a baby mediator back in the late 80s. And we were getting the canned, what I'll call the canned training from the Florida program. And it was very, thou shalt do the following in your opening statement. Do not offer perspectives or opinions. Do not go anywhere near that. You're purely there as an extension of the parties, and not they're not interested in and will not be benefited by your perspectives on anything. So you've got this tension between that abiding reality, which still pervades in some places, and I think the evolution of the field, which is more in the direction that we would describe. We're simply trying to say, I would like to think that our training, our education, doesn't impose our own unrealistic perspective on reality, but to say let's try to take our guidance from the circumstances and have the tools, a range of tools available to deal with those.
So looking at the dispute as a dispute and not as necessarily a family dispute or a construction dispute or a partnership dispute, this leads me to ask you a question about subject matter expertise. In our jurisdiction, our mediators are often chosen on the basis of subject matter expertise, right? Mm-hmm. Justice so-and-so on the bench was well known for resolving, some corporate issues. So there's a good person to go to. Stan Naftalin is a famous Canadian construction lawyer here today. He's the guy to go to with construction cases. You pick someone else for a family dispute. And I see the market doing that, but doesn't that work against, Tom, what you're trying to achieve in your program? Is the market working against that?
Well, I've never thought of it that way, to be quite honest with you. Maybe, I'm just, I guess I sound like I'm kind of laissez-faire about a lot of things, but I really believe that there's room for the specialist mediator, and some people want specialization in mediators. They do want that substantive experience, as well as the omnibus, the great commercial mediator, or the great someone who is is capable of mediating different kinds of disputes. I will say that the trend is very much, seems to be in the direction of more specialization.
I see.
And that is just, I guess, a market reality, but there are some people who have been very successful in mediating a broad range of cases. I personally find that I'm probably most comfortable in construction and commercial cases, and I wouldn't dare, particularly since I just work part-time, and I'm not a full-time mediator,
sure,
which I think is more and more the trend. Very, very sensitive to not going beyond the bounds of what I feel capable of addressing. But I think for people that are out there all the time, it may be that some are able to extend their purview more broadly.
I think, they say it about surgeons, first do no harm. I think that applies to mediators as well, and it's a note of caution, first do no harm. If I was to stray outside of my area, I would not know, I'm sure I would not know if I had settled the case or not. In a family matter, you might have dealt with property, but have you dealt with access and custody and the myriad of issues that go with it? Similarly, patents and trademarks, commercial disputes that have their nuances. So I think that's a note of caution. But it allows me to give another plug, Tom, for co-mediation, correct? So that is perhaps a way through that.
You've just been talking about what the market does to mediation. So let me just skip ahead a little bit in the questions that we've been talking about. I want to understand what are the busiest mediators offering that others aren't. We all know that mediation is susceptible to market forces. Some mediators are busier than others. And what makes a mediator desirable by the market? Is it, for instance, the subject matter expertise that we were just talking about? Could it be that the best mediators are the ones that help the parties accurately frame their best alternative to a negotiated agreement, worst alternative to a negotiated agreement? We were talking about getting to yes earlier, most likely alternative. Even if that process means becoming evaluative, inserting themselves into the process a little more than you, Tom, were saying you'd been taught in the 1980s. And related to that, do complex mediations call for multiple skill sets, maybe multiple mediators, the way Duncan's been plugging?
Well, plugging it. All right,
plugging,
yeah. Right.
Mentioning.
Okay, I'll take that.
Suggesting. So let me sort of leave you with those questions about what effect does the market have on what we're seeing from mediators and why some mediators are in demand and not others less.
I didn't bring the article with me, but I did a short piece for the ABA Dispute Resolution magazine on some data that we got out of a study we did with the International Academy of Mediators, which is, I'd say, probably half Americans and then half mediators from other jurisdictions. There are, I believe, some Canadian mediators in the group, but also from Europe and other countries. The leading lesson that I got out of that is that this is a group of very successful mediators. On average, they've mediated over 1,000 cases. They have a wide variety of styles. They employ a variety of different approaches, particularly when it comes to directiveness, evaluations, that kind of thing. We ask a whole series of questions about that. What you find is you get a complete spectrum of behavior. And it varies to some extent within regions, but there are also regional tendencies or trends. For example, in Los Angeles, there seems to be a decided orientation toward more caucus.
Oh, interesting.
Beginning in caucus, and in some cases staying in caucus. There is a small percentage of mediators who, as a rule, just keep people in caucus all the time. And again, this is particularly pronounced in Los Angeles. And part of it is there seems to be a real penchant in the Southern California bar for caucus. And one might posit that it's because it allows counsel to maximize their own control over the process, what their client hears and doesn't pick up. We actually had some comments from the California mediators to this effect, that the local bar in places like Los Angeles is just very emphatic that they don't particularly like joint sessions.
Interesting.
And they send this message to mediators. So if you're going to be a successful mediator of litigated cases in Los Angeles, I guess you pay attention to that message. Now, that varies considerably from what you might see in other parts of the U.S. And in fact, when I presented this data, I didn't realize, I just presented it in aggregate. And I had a bunch of California mediators up on the stage with me. I didn't pick the panel, but it turns out they're all from California. And they're all caucus, and caucus all the time. And or at least the moderator was sending this message. Well, there were mediators in the audience who who were really beginning to get agitated. And one got up and said, I think we need everybody up there to sit down, and we're going to replace it with a panel of people who know what they're talking about. I mean, it was just, and we almost had a fist fight among mediators. And I thought, hey, this is really interesting. So I went back, and that's when I found out, within any region, you get you may get certain tendencies, but you have a range of behavior, and even experienced mediators, their default practices vary. But then you get these regional differences. And it is fascinating. Why is that? It's just, for me, I guess it just raises questions. It gives me more things to ask and more things to talk about. But I don't have answers as much as I do simply, well, what does this mean? Is this a good thing? Or, do you know what you're doing?
There's so much to respond to there, Tom. There are fashions that I think blow through the mediation community. And disparaging the joint session is very popular. So for mediators in Canada to poo-poo the joint session and have, it began as saying, let's not have opening statements because they'll just inflame the parties, right?
Yeah.
So it started with that, and then it became received wisdom that you don't have them, that you have a few remarks by the mediator, you go into caucus. So I think a Los Angeles attorney would be comfortable in this market. But going back to making the most of mediation, going back to our title, going back to the outcomes versus process sort of dualism that we're talking about, I've heard another point of view, and I've seen it actually, that there's a lot of pent-up energy and emotion when you walk into a mediation room as counsel. You know it as a party, you know it. As a mediator, you see it, you feel it. And if you can control it, under the heading first do no harm, if you can manage it, there is a lot to be said for getting that out there. That so-and-so, if he calls me a fraud in this room, we're packing up and going. You've got to be able to manage that. But in my very limited experience in encouraging that kind of thing, which I'm doing very gingerly, there's something to be said for that. The second point is the deep irony of a lot of what mediation is involved in is not lost on me or you obviously at all, but the choice of mediator, cognitive dissonance, has a lot to do with that, Tom, right? No one would pay that much money for a mediator unless they were very, very good, right? So, there's that, but it's such an active reputational market. There's very little genuine advertising in the Canadian market. Anything you'd recognize as sort of touting one's skills, and a lot of it is word of mouth. Do you see mediators advertising in the U.S.? Is that something that's done, or is it a sort of an underground telegraph kind of?
Well, there are certainly ways that people can get their names out there. It's not as much direct advertising as it might be, having biographical information posted online under the rubric of JAMS or whoever it happens to be. But as you say, the word of mouth, the reputational filtering that goes on, I think is very, very significant and probably the single most important pipeline for cases. Before we move forward, let me just come back and emphasize that although I in this discussion of caucus, I want to make sure it's understood that I truly appreciate there are a variety of reasons why someone might believe that a caucus is necessary, even at the beginning of a mediation, for a variety of reasons. I have had circumstances where the vast majority of time is spent in caucus. Maybe most of us have, but I've had a few situations where we were able to keep everyone in joint session for the entire time. Right. So again, I think it comes down to cases and people. We probably all begin to develop our default expectations, but at the same time, I think circumstances should dictate what happens.
And Jay, just before, I don't know if you're ready to move on, but just before you do, Tom, one other characteristic that I think certainly for my Canadian experience would distinguish some of the best mediators is what I would call stick-with-itness. There's a feeling of investment in the parties by the mediator. And there's several mediators who are known for this. They become invested in the problem. They take it on as their dispute. And and stay with it. So the parties are unable to manage a resolution on day one. The mediator, sometimes without fee, will stay with it. Is that something you see? Is that something, or is it even advisable on a theoretical level to stay with a case like that, to own a case like that?
You know, I have to say that I've been thinking more about that lately. We have to remember that what we're talking about, the kinds of matters that we're typically involved in as attorneys, it's like the parties are driving down this highway, and you know, it's like Los Angeles or Toronto where you have 6 lanes, and you're moving back and forth from lane to lane. You know, you're driving along, and maybe first in the negotiation lane, then you file a case in court. So you move over to litigation, then maybe you move to unaided negotiation or mediation, but you're moving back and forth. Mark Galanter, University of Wisconsin law professor, coined a wonderful term, litigation,
Right.
which I think is really accurate. We litigate. And the other thing to keep in mind is that this is not a linear thing. We have these stages that we set out in conflict resolution clauses, you know, where you have stepped negotiation
Tiered.
or whatever,
Yeah.
tiers.
Yeah.
But the fact is, so often I find the cases that whatever role I'm playing, maybe I'm the arbitrator, and you know, I may be, I know the parties are out there thinking from time to time about negotiation or mediation. Sometimes they mediate a couple of times
Right.
during the course of a process. So I remember a subcontractor brought into a multi-party case recently that I was arbitrating, and he blurted out in a conference call we were having, well, have we mediated yet? Usually by this time we've mediated twice, you know. So we moved on, but the fact is, this is nonlinear in many cases. You're moving back and forth between litigation and negotiation, usually with the assistance of a mediator. And so I think I really like the idea as a mediator of trying to maintain that connection. If it's possible. It's not always possible, but recognizing that, you know, again, thinking about it from a process point of view, simply staying with it may make the difference, but there may be a procedural posture that changes as the case moves toward trial or arbitration or whatever, where information comes out, decisions are made that will completely change the landscape. And make the case more amenable. Let's face it, in the U.S., the vast majority of these cases are going to get settled.
Right.
And sometimes, even after arbitration, there's an opportunity for settlement. Goodness knows. So there's always the opportunity to move over to the other lane. Maybe the mediator can remain a part of that process as long as the mediator can ride that process. So.
Tom, that leads in really nicely to what is going to have to be our last topic for the day. I want to save a little bit of time for questions from the audience, and for our audience that's watching, we have a large audience watching by web. Please feel free to take this time to think of questions, which you can, I believe, insert into a comment box, and we'll have an opportunity to pose it to our panel. But Tom, you were talking about dispute resolution relatively early on in the process, and I'm wondering, looking ahead into the future, is there room for more kind of that real-time dispute avoidance or preventive mediation, such as, for example, during commissioning and turnover of a project, or during e-discovery to resolve or attempts to resolve a troubled partnership a little bit earlier? And well, this is our last question. I have one eye on the clock and want to give our audience time, so I'll ask you to keep your remarks brief. Thank you.
Yes.
Maybe not that brief.
Well, that's what I like about Tom. He knows his mind. That's great. I think, and Jay's doing me a personal favor here because I wanted to make sure that we had this question asked. So thank you, Jay, for fulfilling your promise to me. Tom, now that we have you trapped at the desk here, part of the topic, making the most of mediation, inevitably is talking about the future of mediation. The idea we chatted about was, let's take this fabulous idea that's working, and if we can, make it better. And it fits within the world of, you've mentioned dispute review boards, dispute adjudication boards. There's adjudicatory and non-adjudicatory. There's, we have any number of names for any number of processes, but the ideas we've been discussing that make mediation work, to me, are fascinating. So I do see, this was last week, I think, was the anniversary of the Halifax Harbor explosion. Oh,
yes.
Right? The two ships.
Very famous.
Yeah, very, very famous. And it's worthy of a Curry lecture for you at some point, I think, worthy topic. But you see, metaphorically, as a project, a large infrastructure project reaches or gets near completion, you see the large ships unable to alter their course and heading for each other with calamitous results. So not to strain the metaphor, I've often thought that having a mediator, somebody with the jurisdiction of a mediator, not necessarily a dispute review board or dispute adjudication board, engaged by the parties at that stage of a project would be good. Someone chosen not at the outset of the contract, but someone chosen in the circumstances that arise towards the end of a project. So that's one setting. Mediating between insurers and insureds, for example. There's a lot of, I consider, often wasted money spent on those cases where there might be a better solution. So maybe if I can get you just go beyond yes a little bit, let's chat about that, Tom. If you could look ahead 5 years, what would you like to see mediation become in that period of time?
Well, I would love to see more experimentation with mediators coming into the process earlier, before the spiral of conflict has spiraled so much, and perhaps before the parties have solidified their legal positions with assistance of counsel. I think there are a lot of opportunities like that, and I've actually experienced it. I think that the question is, how do you advance a value proposition that companies can understand, that people who are making business decisions can say, yes, I see value in having a facilitator get involved at this level, as opposed to simply bringing in my lawyers when conflict rears its head. And of course, those are not mutually exclusive possibilities, but nevertheless, I think timing is so important. And we do see a variety of examples, the healthcare area, employment systems, et cetera, where neutrals are able to come into play earlier and play a variety of roles. Right. I think one interesting question is, what is it that parties want at that stage? What is most effective in getting conflict resolved? It is interesting that the one area where we've seen this develop in the construction arena is dispute boards. Right. But dispute boards render decisions. Right. They may be advisory or preliminarily binding. But what is it that parties want and need there? I, like you, have always said, it seems to me that in addition to evaluation, a non-binding or binding evaluation, it would be nice to have the broader role of a mediator. Right. I see real value there. How can we make other people, or how can we bring other people to the point where they see it? Right. I don't know, but that's an interesting question. Maybe only success stories will breed success. Right. But I think there are opportunities for that, and even facilitation from the beginning of a team. Sure. So I have some experience with facilitating partnering back in the 90s, and I thought that was going to be the future, but it wasn't. Right. So, the fact is, I think there is more room there.
Great. Thanks, Tom.
Thank you, Tom. I'd like to open the floor to questions from the audience. Does anybody have a question for our panel? I'll bring the microphone back, Dante, so that you can people from the web can have the benefit of the question.
Thanks, Jay. So I'd like to thank you both for what was a very enlightening discussion. And Jay, in your question, two, in your enumerated list, you talked about forgiveness and reconciliation. And there was a lot of discussion today around cultural differences and different approaches. Mr. Stepanovich, as a deacon, I'm just interested to know what parallels, if any, do you draw between being a deacon and your role as a mediator? And part two, what role does faith, if any, play in your role as a mediator?
Well, thank you for asking that. I do have to say that I see my role not just as a mediator, but as an educator, as an extension of my faith. And I frankly, I don't like to think of myself as someone who proselytizes, but I believe that, to me, faith is action. That is the most effective evocation of one's faith is by one's daily activities. And so for me, the opportunity to try to ameliorate conflict, to take people beyond all of these stages of that they go through in disputes and bring them safely home, maybe to a new understanding of themselves and of other people. Something I've experienced myself in conflict is a wonderful opportunity. It comes back to what Duncan said at the beginning, which is that we're very privileged to be resolvers of conflict. I think it is a very high calling. Anyone can be a resolver of conflict, but we're given particular opportunities and a particular position. We have a professional calling to be resolvers of conflict, and not only that, but in the best sense, in the best situation, transformers of people and situations. So to me, it really comes back to who I am, and I'm not patting myself on the back. I'm simply saying that I just have a visceral need to be in this area, just like many of us, I'm sure, do. We have gravitated in this direction. My own pathway was very kind of a crooked one, but it makes perfect sense in retrospect. And I'd love to hear the stories of you and everyone else.
Thanks for that answer, Tom, and thanks, Dante, for that great question. We've got time for just one last question. This one's coming from the web. David Thomas, our friend at Carillion, asks, in your experience, have you been asked to engage by the parties early in complex cases to help facilitate or structure the mediation process? For instance, agree on time frames, agree on documentary production. And also in your experience, have you been asked to provide a written opinion to the parties following mediation if it has not succeeded, if the mediation has not succeeded?
Yes and yes. I actually, in the construction arena, I found there's a lot of opportunity for active process management, as I'm sure some of our other mediators have. Sometimes I'm engaged very early, and there's always the question that's in the back of the lawyers' minds, I'm sure, do we have the information that we need to move forward with a negotiation? Do we know how we can frame a dance floor without having X or Y piece of information? And so I know that that's going to be something that comes up. The question is it going to prevent mediation from moving forward at all, or is there a way that we can make that part of the process, getting that information out on the table? So, another piece of process is to say, are there teams of people who might be able to work together, for example, or maybe project managers or someone else who have a good working relationship? And we can build on that with the support of principals, with the support of the parties, to actually begin to build resolution of individual conflicts, individual claims or controversies. So that's an answer. I've also been asked from time to time to render opinions. And I mentioned, I think I had a couple of examples where I actually rendered a binding decision. That baseball arbitration I told you about, where I was asked to choose between two final offers. so several $1 million apart. And the parties, as I said, they said, we both know this case backwards and forwards. We know, we have perfect information really about each other's positions and interests. Please put us out of our misery and make a decision. So that's what I did. And the fact is, sometimes there is room for that. There are some mediators who actually have made that kind of approach their calling card. Sure. It's not a normal thing, but there are people who are known to do that and actually market that.
Tom, it has been not just a privilege but also a pleasure to have you here today. I want to thank you for making the trip, and I'll ask our audience here to join me in thanking you for being on our panel today.
Thank you.
Thanks very much, Tom.
Thank you, Duncan.
Thank you to Tom and Duncan, and thank you to our audience in person and on the web for joining us.
And do pick up, Jay, make sure everybody picks up the journals and literature that's out front. Yeah. Okay, great.